Counsel?
Good afternoon, Your Honors. With the Court's permission, I'd like to request 2 minutes of rebuttal time.
Yes. Counsel, why is it that a defendant can waive their right to be present based on their conduct or their behavior, but they can't waive their right to be present at sentence based upon a knowing and intelligent and voluntary waiver given in open court in the presence of counsel?
Well, there are two separate analyses that are being presented in that scenario. We have the forfeiture analysis, which occurs by operation of law based upon a defendant's either misfeasance or a non-compliance with a certain requirement. And then we have the distinction with the waiver, which is a knowingly, voluntarily, and intelligently made relinquishment of a known
Would
right.
a lawyer be smart, if we find your way, to say to his client, don't get out of the cell? Don't get, when they try to put you on that bus, because you're going to get woken up at 6 in the morning, you're going to get a half a breakfast, you're going to be on the road for about 4 hours, you're going to end up at Attica, you're going to sit in Attica for 8 hours, and then when you finally get over to court, you're going to be one of 16 people, and you're going to sit there in the bullpen until that's done, and in the meantime, you're then going to get taken back to Attica, and put back on the bus, and the next day you're going to go back. So don't get on the bus. Then they're absent, and they win. But because we can't say you can waive it.
Well, that doesn't necessarily mean they win. What that means is that the court, the sentencing court, would be making a determination whether that conduct rises to the level of forfeiture.
And we would say it does. And for some reason, we have this weird thing where the best thing to do is to tell your client to be obnoxious, obstreperous, and not comply with the correction officers at the facility he's at. Right?
Well, if they forfeit their right to be sentenced, they can be sentenced in absentia. It's the contrast of the waiver where it's inappropriate for the court to completely disregard what the legislator has mandated, that a defendant must be present at the time a sentence is pronounced
Do you know why
for a
they
felony.
did that? You're right. It's pretty clear. I mean, it's one sentence. It says they must be there. Why? As Judge DiFiore says, you don't have to, but they say you do.
That's correct, and I think when you look to the criminal procedure law as a whole, the legislator has taken the time to evaluate.
No, take that out. I mean, we know the CPL, and we know that the legislature works hard and they make reasoned decisions. Why this one? I mean, did they say, we don't like the fact that defendants may abscond and not be there for sentencing? No, because we say that's okay. So why do we say you have to be there?
There are certain policy considerations
That's
that the
what I mean. What are
legislature likely took into consideration. Arguably, some of the most important things that happen at sentencing require a defendant to be present. One of the examples would be the review of a pre-sentence investigation.
To review a pre-sentence?
The review of a pre-sentence investigation and ensuring that there aren't any errors, because that document will later be relied upon by the Department of Corrections.
That is to the benefit of the defendant, right? So if the defendant knowingly waives
Correct.
their right to be there and they're represented by counsel,
that is correct. And there
why
are
aren't their
also
interests then protected in those kinds of cases?
there are certain societal interests in that a victim may have an opportunity to confront the convicted person at that
They
time.
can come. They can be there.
Absolutely, but there's certain historical significance in ensuring that a defendant is present when a sentence is imposed.
No, you said the victims have to have an opportunity. Well, they can come even if the defendant's not there.
Well, there's certainly a difference between a victim attending a court proceeding with an absentee defendant and a victim having the opportunity to appear in court and
But if
face.
the defendant waives in writing according to the statute, the victim loses that opportunity, right?
Correct, and that would be.
So obviously that doesn't overcome the defendant's right not to be present if he or she doesn't want to be.
That is correct, and there is a distinction between the misdemeanor and petty offenses and the felony offenses, the felonies being more serious than the lesser offenses, and that's something that the legislator likely took into consideration when making the determination that it was necessary for a defendant to be present at the time that the sentence was imposed. But I agree with you, Your Honor, that the statute is abundantly clear here, and it just wasn't followed in this particular case.
But it strikes me that either he knew that. I mean, this defendant is in 3 counties. He's trying to bundle 3 pleas into one sentence, all of which makes eminent sense, and everybody's being cooperative. His lawyer says, Judge, we'd like not to be here. The judge very calmly said, absolutely, if that's what you want to ask the defendant. The defendant said, nope, I don't want to be here. And now that all of this is done, he's the one that comes up and says, I wasn't there, and therefore I'm entitled to be resentenced. And the suspicion, at least one judge's mind, is that he's hoping to renegotiate all 3.
And that's certainly a possibility, because if this court rules favorably for Mr. Rossborough and the matter was remanded to the sentencing court, he would be restored to the position of pre-sentence and would be in the position where he could make certain motions under 330 in order to withdraw his plea. I don't know if that would go anywhere potentially, but that is certainly a consideration.
Do you agree that under the circumstances here, notwithstanding the statute, that the waiver was knowing, intelligent, and voluntary?
Yes, there was a
The court did
colloquy.
everything to make sure that that was appropriate.
Correct, aside from the not following the proper procedure with respect to how a waiver should be made with respect to waiving the right to be present for sentencing. But the
And because it's not in writing? Is that what you mean?
Correct,
It's
and
an
there were,
oral.
yes, there were certain provisions that the legislator required in terms of that the waiver be in writing, that it contained certain information with respect to the maximum sentence, and made upon motion to the court.
Just to circle back, perhaps I didn't fully understand your response to the Chief Judge's question. So if the statutory mandatory language of 260.20 regarding presence at trial is similar to the language at issue here, and again, the right to be present at trial is waivable, why isn't that the case here?
Well, in the 260-20 language that you referenced, there is no distinction that's drawn between a misdemeanor and felony level offenses, which is why it's significant in that the legislator obviously took care to ensure that a defendant would be present at the time of sentencing, but they did not draw that distinction for other material stages of the criminal
Counsel,
proceeding.
do you agree that the right to be present at trial is also constitutional? It's not just a statutory right?
Absolutely.
And if a defendant can waive the constitutional right, are you saying that the defendant cannot waive the statutory right?
Correct. And there has been numerous occasions where this court has found that a defendant can waive a constitutional right. However, the court has never found that they can do that when there's a statute that directly opposes waiver of the right to be present. This court has found that a defendant can waive the right to be present for a Sandoval Ventimiglia hearing, a Wade hearing, the presence during jury selection. However, there aren't any statutes that specifically require a defendant's appearance, and that's the distinction in this case.
Yeah, there's a case, Corley, 67 New York 2nd, that says any right defendant may have to be present at sentencing can be waived, one, or lost as a matter of public policy when the evidence unambiguously indicates defiance of the process. Doesn't that seem to indicate you can waive?
Well, this court, when deciding Corley, merely referenced the issue of waiver in dicta. That case boiled down to forfeiture, and what's interesting about that particular case is it was decided 4 years after this court decided People v. Parker, which applied the waiver analysis to a defendant's absence during trial. People v. Corley, with very similar conduct of the defendant in that particular case, after the indictment was reinstated following an appeal by the people, the defendant was placed on notice by the court, by defense counsel, and continued to fail to appear. The court indicated that he had forfeited that right. So it is interesting that People v. Parker applied a waiver analysis to a defendant's failure to appear at the time of trial, while 4 years later, this court decided that the forfeiture analysis was more appropriate. So though it did address waiver in the decision, ultimately it was a forfeiture case, and that waiver language was simply dicta.
Thank you, counsel. Counsel?
May it please the court, Eric Sheener from the Wyoming County District Attorney's Office for the respondent. The people respectfully submit that the Fourth Department's unanimous decision should be affirmed as it correctly held, one, that the defendant's waiver of right to appeal encompassed his 38040 claims, and in any event, the defendant's appellate claims are without merit.
Counsel, is this a common occurrence in your county?
It is, Your Honor. Wyoming County has a maximum security facility at Attica. Crimes are committed by the inmates at Attica. And therefore, they almost on a monthly, sometimes weekly basis are brought to the Wyoming County Court. Unfortunately, in the time between the crimes are allegedly committed and the indictments, DOCS usually moves the individual inmates all across the state, scattered to the four corners of our state. Therefore, they are then transported in those blue vans that we see on the thruway, oftentimes days, sometimes weeks in advance, having to travel in shackles along the byways and highways of our state and then spend time back at their original facility.
Well,
where many of them-
do you know the rationale for why this legislation, why there's a mandatory appearance by a person who's committed a felony at sentencing? Do you know what the rationale is?
I could not glean that, Your Honor, from the legislative intent. I know appellate counsel goes into great length on the statutory construction arguments, but I think it would come down basically to the same kind of analysis that this court did in Epps on the right to be present at a jury trial. It's so that things aren't happening in secret. It's more of a safeguard for the defendant that the court doesn't do something in secret or impose a sentence that they're unaware of, something of that nature.
So you think it's aimed at the court saying he must be present, not aimed at the defendant saying you must be present?
Well, I think it has two goals, but I think that originally that it was more of a safeguard against courts doing things without the accused's knowledge. It certainly has.
So why wouldn't the exception just be a general right to waive? Why is it written as written, which is only about a particular category of
Again,
offenses?
it's not abundantly clear, and especially when the code changed in '67, it still wasn't addressed. I acknowledge that there was that provision for misdemeanor and petty offenses, and I can only surmise that was because of the volume of those matters and the necessity for judicial economy.
Counsel, can a voluntary waiver occur if the defendant didn't know what the sentence to be imposed was?
I don't think that would be appropriate at all. I think that this is a case where everything was going according to what that defendant knew. He knew exactly what he was pleading to. He knew what was happening in the other counties. He'd already been sentenced in 2 out of the 4 total counties, and so there were no surprises.
Would it make a difference if this were a sentencing that were to take place after a trial had been conducted?
I would submit that is absolutely true. Or in a case where a defendant was at liberty, either on bail or ROR, and would have, no idea of what the terms and conditions of a community-based sentence may be, or what the terms of their sentence may be. But in this case, everything was known. It was going to be concurrent. He was already in docks and knew that he was going to stay there for some time.
Well, if we were to decide in your favor, would the waiver on the record as opposed to a written waiver be sufficient?
I would submit that the waiver was knowingly and intelligently and voluntarily given. He was advised of the consequences, and Judge Griffith went to great lengths to tell him that if there were any hiccups or any changes, we would bring you back and we would address them.
Yeah, but he was in custody. Counsel on the other side, I assume, could argue easily that if you're OR and don't want to come back, are we going to treat them differently? We're going to say no because you're OR, you must be back, as opposed to if you were incarcerated.
I think there is a distinction there, yes, and I think that these cases, although Rossborough was not an inmate case, so to speak, this does apply, as Chief Judge indicated, on those types of inmate cases. But if someone was on release, certainly their appearance at sentencing, I think, would be mandated.
So let's say we agree on the waiver. We agree that this particular waiver that's not in writing is also satisfactory, appropriate. Would that mean we're basically excising the exception?
Well, as counsel indicated for the appellant, that written waiver seems to apply to that misdemeanor or petty offense.
I understand, but does that then mean that you get greater protections with petty offenses and misdemeanors than you do with the more serious crime? I.e., this has to be in writing so that you have some assurances that the person has been properly informed, but not with the...
I would certainly submit in an ideal world and in an ideal setting that a written waiver would have been preferable here. But I think having it come at the request of the defense with assigned counsel, knowing that there would be no surprises, and if there were surprises, he'd be coming back, that the oral waiver was sufficient.
Also, I'm just curious, you say that these cases are kind of numerous in your jurisdiction. And what about the petty offenses and misdemeanors? Is there a waiver form that the court has, for example, like the waiver form for an appeal, when you waive an appeal?
There are forms in the local justice courts that would be handling most of the misdemeanors and petty offenses. But the felonies and the ones I referred to earlier, the inmate cases, the judges, when Judge Smith took this case up to the Court of Appeals, have been reluctant, because those requests continue month after month. The inmates do not want to travel, as some of them have put, the I Love New York tour back to Attica. And it's for any number of reasons. They lose services. They're not sure their property will be guaranteed to be there when they get back to their home facility. So I know that the appellant has made a point of policy decisions based upon, that they wouldn't have an opportunity to input on their PSI or so on. Remember, defense counsel was there at sentencing. Defense counsel could still advocate on behalf of the defendant.
Would defense counsel be required to be there?
He was, and he indicated he would during the process.
But in other cases, if we were to say that a written waiver is not required and a defendant can waive the right to appear, a felony defendant can waive the right to appear at sentencing, do we then have to say also, as long as counsel is at sentencing?
I would think that would be a great idea. I think that would be, this wasn't the first time this happened in Wyoming County Court, and that had been the matter of course when these types of situations arose at defense request. The defense attorney assured his client that he would be there at sentencing and advocate on his behalf if needed.
Thank you,
Okay,
counsel.
thank you.
Counsel.
Just briefly, Your Honors, the respondent has raised some policy considerations with respect to some of the inconveniences or cost effectiveness of transporting state prisoners to and from different court proceedings. However, the inconveniences and impracticalities certainly should not permit a court to completely disregard the law.
It strikes me, though, that I think this is a game on the part of this particular defendant. I don't know a reason in the world why he agreed to this and then said, I'm going to appeal and hopefully, redo the whole thing. And for that, there may be tens, hundreds, perhaps thousands of inmates all over the state who, if we were to agree with you, are going to end up, doing things they don't want to do, where the correctional system doesn't want to do it, in front of a court that has no inclination to do it either. So we're going to say the courts, docs, and all these inmates are going to pay a price because this particular person, after agreeing not to be there, his lawyer's there, nevertheless appeals. Does that make any sense to you?
Those
Hard
are
question.
valid policy considerations, but they're best raised before the state legislator, and it's not up to the court to legislate when it's more convenient. With respect to the waiver of appeal that...
Does that also mean that if we determine that the defendant could waive presence at sentencing, that we are also unable to say that that waiver does not need to be in writing because the statute limits that to a particular category?
Well, in essence,
We'd be
yes.
adding something into the statute because we think it's the right thing, but not what the legislature chose?
That's essentially what it would be doing. If the court decided to uphold the Fourth Department decision, it would be essentially creating new law, creating a new provision that specifically addresses the waiver of sentencing for a felony appearance. So it would be, I believe that that's best addressed before the legislator and not up to the court to decide. With respect to the waiver of appeal issue that the respondent did raise, this court's decisions in People v. Dokes, People v. Antimarchy are nearly analogous to what happened here. Both in Dokes and Antimarchy, the defendant failed to object to particular trial proceedings being a Sandoval hearing for Dokes and sidebar conferences in Antimarchy, and this court did hold that failure to object was not fatal to the claim. That's exactly what happened here, so I would submit that this falls outside the scope of waiver of appeal. It does constitute a mode of proceedings error, as that was decided in Dokes and Antimarchy, which are the controlling cases in this particular case. It does fall outside the waiver of appeal and is preserved for this court's review. And if the court doesn't have any further questions, I do see that my time has expired. Thank you very much.
Thank you, counsel.